Mediating preference actions in bankruptcy cases. This is our topic for today, part of the series Bankruptcy Mediation with Sylvia Mayer.
Welcome to the Lawyers and Mediators International Show and Podcast by instantmediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent.
Hello and welcome. I am Natalia Ołowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland. Today speaking from Houston, Texas.
Hi, this is Pierre-Louis, attorney, mediator, and arbitrator from Houston, Texas.
Hi, I'm Sylvia Mayer. I'm an arbitrator, mediator, and attorney located also in Houston, Texas. And one of my areas of specialty is bankruptcy mediation.
Sylvia, it's a pleasure to have you again. And today with a very special topic that, according to what we've learned also from you, is very commonly met and very suitable for mediation with some difficulties that can arise. And this topic is preference actions. And Sylvia, if you can just briefly describe what the preference actions in bankruptcy cases are.
Absolutely. Thank you so much for having me today. So first, I just want to say that all of my comments today apply equally to the plaintiff and the defendant in a preference action. And if you are ever sued in a preference action, I strongly encourage you to consult with an attorney. Now, with that caveat, I will try to explain something that can be somewhat complicated, but explain it in fairly basic terms. A preference action is when the bankrupt company, it's a estate or a trustee who is appointed to liquidate assets for that estate, sues a former creditor, somebody who was owed money prior to the bankruptcy filing, to claw back a payment that was made before the bankruptcy. Congress enacted this statute as a way to equalize the recovery amongst unsecured creditors. And the idea is if one unsecured creditor was treated preferentially prior to the bankruptcy filing versus other unsecured creditors, then the money can be clawed back to be shared equally amongst the unsecured creditors. The basic elements are that a transfer is made to or for the benefit of a creditor on account of an antecedent debt, meaning it was not made at the time of the debt, it wasn't contemporaneous, it was made to pay a debt that was owed, within a 90-day period prior to the bankruptcy filing. I'm only talking about non-insider claims, if there's a whole different set of rules for insiders, at a time when the debtor was insolvent. Now that is actually under the bankruptcy code presumed, so it is rarely an issue that is litigated in these cases, and that enabled that creditor to recover more than it would have received in a Chapter 7 liquidation. The areas where you see people fight the most are around whether or not the payment was made in the ordinary course of business and whether there was new value. And those two concepts are the primary two defenses to a preference action. So that's really a really quick overview of something that's far more complicated.
Sylvia, can you go into a little bit more information about the common defenses that you typically would give? And could you give it in the context of a hypothetical scenario?
Absolutely. So as I mentioned, the two common defenses that I see to preference actions are new value and ordinary course of business. New value means that after you received the transfer, which is just a payment on an invoice, after you received that transfer, you continued to extend credit. And the idea underlying that, the policy underlying that, is that then you're owed money when they filed bankruptcy. You continued to extend credit. You didn't just get paid and say, that's it, I'm done with you. The ordinary course of business defense has two different prongs. One is the objective standard and one is the subjective standard. You don't really deal a lot with objective standard in a mediation because in order to satisfy the objective standard, you need expert testimony. And so as a general rule, parties come to mediation before they're going to spend that kind of money. It can come up. I certainly had it come up, but most of the time, people are focused on the subjective prong. The subjective prong of the ordinary course of business defense analyzes the history of payments between that creditor and that debtor. And it looks to see if the payments that were received in the 90-day window, meaning the 90 days before the bankruptcy filing, were paid around the same time, meaning the same time between invoice and payment, in the same manner, and through the same types of communication. So a classic example of something that would be a preference is if the history of payments were that you were paying, you creditor, vendor, were getting paid 30 days after you submitted an invoice. And on day 89 before the bankruptcy filing, so within that 90-day window, you sent an invoice, and on day 88, you called them up and you said, I sent you an invoice yesterday. If you don't pay me by tomorrow, I will stop shipping goods to you. And you documented that. You not only called them up and said it, but then you sent a confirming email that reiterated it and said, what I told you on the phone was, if you don't pay me that invoice I sent yesterday by tomorrow, I will stop shipping goods to you. If you get that payment, you have a lot of exposure. Why? Because you just got paid in 24 hours, which is different from your historical 30-day payment period. And you have documented evidence that you demanded payment and threatened cutting them off. So I picked an extreme example. Those sometimes happen, but most of the cases that I see in mediation aren't quite that stark. So that would be the ordinary course of business defense. There's a lot more complexities to some of this, and particularly if I go back to the new value defense that I was talking about, one of the issues that comes up there is new value is that you continue to extend credit. But one thing that is fought about in almost every mediation I have is whether you still have to be owed the money for which that new value was extended. Why? Congress also established a special protection in the bankruptcy code under section 503b9 of the code that says that if you delivered goods in the 20 days before bankruptcy filing, you're going to get paid that as a higher priority claim. And so one of the issues that people argue about is, should they get new value credit if they got paid on it as a 503b9 claim? Some jurisdictions, courts have already ruled, and so you actually have case law that governs it. In many jurisdictions, courts have not ruled, so it's an issue that people argue about. And that can have a very significant impact, particularly if you're delivering goods every day or multiple days a week prior to the bankruptcy filing, because you could have been owed a huge sum of money as a result of that 20-day period that you got paid. And you want to be able to use it as a defense for new value, and the plaintiff, which is the debtor or the trustee, does not want you to use it. And so you fight about that. So sorry, I know that's a lot of information and it's complicated, but that's my oversimplification of it.
Okay, and on top of that then comes the mediation. And I know it's very special because it involves a lot of people's emotions. Can you tell us what people generally complain about? What brings them into this state of very high emotions in this sort of mediations?
Absolutely. So I often have to explain to the plaintiffs in a preference action that while they are unemotional about what's going on, the defendant is not. The defendants frequently are very emotional, and it's understandable because many times these defendants who are creditors, typically vendors who were delivering goods or services prior to the bankruptcy filing, had a claim that may have not been paid or only paid at a very small fraction of the face amount of the claim in the bankruptcy. And now, a year, 2 years, a little bit longer after the bankruptcy was filed, they're getting sued to put money back. And so people come in and they will be very emotional about it. I already lost money because this company filed bankruptcy. I did nothing wrong. Why are they suing me? Now I have to have the expense of an attorney. They are really upset about it. And I typically spend at least a good, it depends on the case, but at least 30 minutes to an hour talking to the defendant and hearing them and letting them share with me their frustrations and their concerns and their distress over the situation, because it is upsetting. Your business may have nearly failed because of this bankruptcy filing, and now they want you to give more money. But unfortunately, this is what Congress said. It has nothing to do, and I tell people this all the time, you did nothing wrong. This is not an indictment. This is not a criticism that you did something wrong. People will say to me, Sylvia, all I did was pursue my collections. That's what a good business person should do. Yes, and that's okay. You didn't do anything wrong, but that is what allowed them to sue you. And now let's see if we can solve this. Let's try to solve your problem and find a way for you to move forward. So similar to every other mediation that we all handle, it's about looking ahead and imagining the future where this is behind you. But first, you have to let people work through their emotions.
So imagining that somebody's out there is listening to this and they were a creditor who had gotten paid and they have just gotten sued, or they haven't gotten sued yet, but certain demands are being made of them. At what stage in the entire mediation, in the entire bankruptcy process, are you seeing these preference actions? And what type of bankruptcy cases do these typically come up in?
So for the most part, you see preference actions in Chapter 11 bankruptcies. Not necessarily the really big ones. I mean, yes, you see them in big ones, but not exclusively the big ones. Sometimes you see them in smaller, but it's primarily in business bankruptcies that run through Chapter 11. And again, it is a Congress-dictated policy that says this is a way to try and equalize recoveries for unsecured creditors. It is very common that a preference action plaintiff, prior to filing the lawsuit, will send out a demand letter to all of the potential preference action defendants. And in some cases, that might be 10, 20, 30, 50 creditors. But in some cases, it's thousands of creditors. They've identified 1,000, 1,000, 2,000, 3,000, 4,000, thousands of potential preference actions. And they send out a demand letter and they say, here's what our records show. We are planning to sue you for X dollars. If you will pay us Y dollars, some amount less than what they're going to sue you for, within some period of time, 10 days, 20 days, 30 days, then we won't file the lawsuit and we'll settle this claim. If, however, you think most of them will say, if, however, you think you have any defenses or information you want to share with us, please contact us and share that information. And so I can tell you, if I change my hat, when I'm wearing my attorney hat instead of my mediator hat, and I have a client who has received one of these demands, then we start analyzing the defenses, and we will frequently engage the plaintiff in a discussion and try to demonstrate that to them that either their claim has no value or has very little value, and try to negotiate a deal. So it's very common to have a preference action resolved before a lawsuit is even filed. But there obviously are lots of lawsuits that are filed, hundreds, thousands of preference actions that are filed. Not always, but a high percentage, I would say the majority of preference actions that go to mediation prior to discovery. And they do that because there's not that much discovery to take. Each side should have the information on invoices and payments, and they have most likely shared much of that information prior to the lawsuit even being filed. And then it's a question of what kind of correspondence was undertaken. And there may be some additional things on top of that that would have to be dealt with in discovery if you can't settle the case. So I'd say the majority of preference action mediations that I do are cases that are in the pre-discovery stage. They're early case mediations. In the context of the larger Chapter 11 case, these lawsuits are typically filed 1 or 2 years after the bankruptcy was filed. And that adds to the fuel of why the defendant is so upset. Because by the time you get to the preference action litigation, the defendant already knows that they're only going to recover pennies on the dollar in terms of what they're going to get paid on what was their claim in the bankruptcy. And now they're getting sued to put money back into the pot to share with other creditors. And it's very upsetting to them.
And then you mentioned that there might be thousands of those actions. I understand that within one bankruptcy proceedings, there might be thousands of those actions. And, from the layman's point of view, it might seem that it is impossible to mediate those thousands of actions that are being brought. Can you tell us how then it is technically organized?
Sure. So it depends on what part of the country you're in. In some jurisdictions, the courts will adopt a panel that they will appoint a group, basically whoever the plaintiff is will go to the court and say, I want you to approve this mediation process. I want you to pre-approve these, whatever, 3, 4, 5 mediators, this fee structure, these deadlines, these protections, these confidentiality provisions, reporting process to the court, et cetera. And in some jurisdictions, courts will sign those orders routinely. In other jurisdictions, we have judges who either won't sign anything like that or won't approve a panel or won't approve some of the requests. And it just varies by jurisdiction, which is kind of similar to a lot of issues that come up in cases all around the country. But typically what will happen is the plaintiff will have a list of mediators, whether it's a court-approved list or just a list that they use. And they'll share that with the parties, and then they'll select a mediator and move forward with the process. But they will be mediating in a big case. They could be scheduling 2 or 3 mediations in any given day as they work through the hundreds or thousands of cases that they have within that bankruptcy, preference actions that they have. Because each preference action is its own separate lawsuit that is filed within the larger bankruptcy case.
Yeah.
And, as a mediator, it is sometimes helpful if you do have the opportunity to mediate several cases with several preference actions within one bankruptcy case, because you learn more about the case and you learn more about what are the issues that people are litigating over in that particular case. And that is helpful for both sides, both plaintiff and defendant, for you to have that greater understanding.
And Sylvia, everything that you're talking about today applies to both creditors and debtors, right? For plaintiffs and defendants?
Absolutely. It all applies to both sides. And, I want to offer people who are coming to mediation, whether you're plaintiff or defendant, so whether you're debtor, trustee, or creditor, a couple of tips. One of the issues that comes up in these mediations all the time is that people will make an argument, whatever the argument is. And then the other side will say, well, how do I know that's true? Where's the proof of that? Where's the proof that your contract says X? Where's the proof that the history of payments is you always got paid after 20 days and you got paid after 20 days in the preference period? Where's the proof of whatever your argument is? And so I tell people all the time, if you have an argument you're going to make in the mediation, you need to either share that information with the other side before the mediation or bring it to the mediation so I can share it. Because it's not a criticism of you. No one is going to give you a big chunk of money or agree not to take a big chunk of money just by, trust me, I said this, it's true. They're not going to. You have to be able to prove it up. Another tip that I would offer people when they come to these types of mediations is it is not uncommon. While I don't see it every time, it is not uncommon in preference action mediations for a party to say, I can't pay this. Okay, maybe I owe you, pick a number, $30,000. I can't pay you $30,000 tomorrow. I need a payment plan, or I need you to give me a discount because I simply can't pay that kind of money. This is another example of bring the proof. If you want the other side to accept a payment plan or to give you a financial constraints type of discount, which is rare, and I'm going to caution you, this is rare. People try to make this argument all the time. It is very rare that they can substantiate it. You've got to be able to substantiate it. And that also gets to one other thing. Outside of preference actions, I see people seeking payment plans all the time. So sometimes I mediate, for example, a collections action, not totally outside of bankruptcy. There'll be a collections dispute. And it's very common in collections for somebody to negotiate a payment plan. Not as common in preference actions. In preference actions, if you want to negotiate a payment plan, then you need to be able to substantiate why you need that payment plan. And sometimes it is possible that you will be asked to provide some additional assurances. So if it's a small business, your principals may be asked to provide a guarantee. If it is a situation where the plaintiff is looking to get money faster versus slower, They may agree to a payment plan, but with a discount if you pay faster. So there's a lot of variables that go into it.
Thank you so much, Sylvia. So we've reached 20 minutes, and as usual, we're always trying to cram all this knowledge into this short period of time so we can give people a good chunk of information in a very short duration. Now, one big takeaway from all of this is that folks need to bring their lawyers if they think this is too technical for them. And everything you just said today was not legal advice. As we said from the very beginning, we want to stress that again because every fact is different, every case is different. So with that, Sylvia, Natalia, thanks so much, guys, for this chat. And we'll do it again, as usual, part of the series, Bankruptcy Mediation with Sylvia Mayer.
Thank you so much. Bye.